Our next story deals with a reverse search warrant, and we're going to read the search warrant. So, reverse search warrant, as far as I know, is not really a term that is like universally recognized at law. But basically, what it is a search warrant would be for a specific person or a specific thing. So, I want to search your property would be a search warrant. So, a reverse search warrant might also be considered like a net search warrant or a global search warrant, or it might be considered a a more of a dragging kind of search warrant, trying to get at everything. And in this particular case, they're trying to get basically cell phone records for anyone who happened to be in the area of a particular criminal offense. And so we're going to read this and discuss the Fourth Amendment law both as it exists and from first principles, because I think it's super, super interesting. So this is a search warrant issued by the United States District Court for the Eastern District of Washington. This is in the matter of the search of information controlled by Google. Our rationale is search for evidence on the basis of crime, and this has been signed off on by a judge, so is now a warrant that exists. Now, of course, Google still has the ability to challenge this warrant. They could move to quash it if they think it's overbroad, and if they can identify any people that would be impacted by this, they could notify those people, and those people could also potentially file notices to quash. So I don't know that this has been executed in terms of this actually happening so far, but this has been something that just that has been released, and so we'll read this. Affidavit in support of an application for a search warrant. I, Matthew Gibson, first being duly sworn on oath on information and belief state. I make this affidavit in support of an application for a search warrant for information that is stored and controlled by Google. I have over 26 years of experience as a law enforcement officer and currently am assigned to the Milwaukee FBI Violent Crime Task Force and deputized Federal Task Force Officer, Special Agent with the Federal Bureau of Investigation for 23 years. And I've been with the investigator with the Milwaukee County District Attorney's Office since May 2015. Based on the facts set forth in the affidavit, there's probable cause to search information for information described in attachment A for violation of 18 U.S.C. 2113 for bank robbery. This affidavit is based on my training experience and personal knowledge, and based on this information, I have a limited purpose of obtaining a search warrant. I have not included every fact known to me concerning this investigation. And fair enough, you don't have to. You have to provide facts sufficient to support it, and you have to provide facts that would directly counter against it. But you don't have to provide everything for very obvious law enforcement reasons. There's a whole bunch of things, first of all, that are just kind of irrelevant. And second of all, you don't want to give any more than you have to, any earlier than you have to. So we have jurisdiction, that is not a problem. Background relating to the Google and relevant technology. A cellular telephone or mobile telephone is a handheld wireless device used primarily for voice communications. They send signals through cell towers. Cell phones may also include GPS terminology for locating the device. Google is an internet company which, among other things, provides electronic communications to subscribers. Google allows subscribers to obtain email accounts on domain gmail.com. Subscribers obtain an account for registering with Google. During the registration process, they ask subscribers to provide basic personal information. Therefore, the computers at Google are likely to contain stored electronic records and information concerning subscribers and their use of Google services such as account access information, email transmission information, and account application information. In my training experience, email providers generally ask subscribers to provide certain identifying information when registering for accounts, such as full name, physical address, telephone numbers, and other identifiers, alternative email addresses, and for paying subscribers means and support of payments, including credit and bank account numbers. In my training experience, email providers typically retain certain transactional information about the creators and use of accounts. This includes the date on which it was created, the length of service, records of login, times and durations, type of services utilized, the status of accounts, the methods used to connect to accounts, such as logging in, and other log files reflecting usage of the account. In addition, email providers often have records of IP addresses used to register accounts. As explained herein, information secured in connection with an email account may provide crucial information as to who, what, when, where, why, and how of criminal conduct under investigation, thus enabling the United States to establish and prove each element or alternatively to exclude the innocent from further suspicion. Further, the information maintained by an email provider can show how, where, and when an account was used or accessed. I've learned Google also maintains records that may reveal other Google accounts accessed from the same electronic device, such as the same computer or mobile device, including accounts that are linked by cookies. Google has developed an operating system for its mobile devices, including phones known as Android. Nearly every cellular phone using Android has an account associated with Google, and users are prompted to add Google accounts when they first turn on a new device. According to some website, in 2017, this system was used by 85% of the world's smartphones. In a 3-month period ending in 2018, there was data collected that indicated that this Android system was used in 60% of the US market, while Apple accounted for 39.7% of the market, which means between them they have 99.8% of the market. Sounds about right, right? In addition, over the past 15 years, the majority of suspects I've arrested have had cellular phones and utilized them in some capacity, such as arranging meeting with co-conspirators, taking photographs of bank proceeds, firearms, and vehicles used in robberies. I don't know that I necessarily want to give pro tips to criminals, but taking photographs of the proceeds of your crimes and the things you use to commit the crimes with may not necessarily be in your criminal enterprise interests. May not be the smartest move, but people being stupid is not exactly a unique thing. Yeah. Let me document my criminality, says Surf Berry Barbecue. Yep, about right. And then people will post them on Facebook. I worked very briefly for a prosecutor's office, and the amount of people that would document their crimes on social media may surprise you or may not, depending on your point of view. But it's yeah, people incriminating themselves is, yeah. Using instant messaging and Facebook posts to sell pills stolen from pharmacies, purchasing firearms which were used in robberies, using web searches to find pharmacies and cell phones that they later robbed, and sending text messages concerning the robberies. Great. Criminals are stupid. Based on my training experience, I've learned Google collects and retains data from Android mobile devices when a Google user has enabled location services. This uses GPS data, cell phone, and Wi-Fi access points. Location data can assist investigators in understanding the chronological and geographic content of email access and use related to the crime investigation. It may inculpate or exculpate the account owner. Okay, great. Probable cause. On October the 13th, 2018, 2 identified male subjects committed an armed robbery of the Great Midwestern Bank in Heartland, Wisconsin. These suspects entered the bank at 9:02 a.m. through the front door. They approached the teller counter and engaged 2 bank employees, while another one loitered behind. Shortly thereafter, one of the suspects left over the counter, displayed a handgun, and ordered the employees to the floor. They removed a plastic garbage bag, opened it up, and they began taking money from teller drawers and placing it in a plastic bag. They asked one of the bank employees for the keys to the vault, which the employees provided. They entered the vault and removed 3 drawers of cash from the vault. The suspects were very calm and very polite during the robbery, despite they had difficulty opening the vault, and despite the fact that they were in the bank for approximately 7 minutes. Okay, they're polite. Probably not a bad strategy, actually, all things considered. You don't want to unduly create a panic, maybe. Everyone get to the ground is one strategy. Everyone remain calm is another strategy. Okay. They fled through the north-facing rear door at approximately 9:09 a.m. with the stolen currency, 1 teller drawer, 2 vault drawers, and a set of keys used to open the vault. External security cameras from a neighboring business show that these suspects were walking north from the bank through a path through a tree line, which abutted a residential neighborhood. According to interviews with two bank employees, there were no customers in the bank at the time. No one else entered the bank at the time. Heartland, Wisconsin is a town with approximately 9,100 people. From a review of surveillance video and witness descriptions, the suspect was identified as an African American male, approximately 40 to 48, bearded or unshaven face, wearing a light green zip-up hooded jacket, blue jeans, black shoes, sunglasses, and green stocking cap. The other suspect was identified as a male, wearing a black hooded sweatshirt, blue jeans, black shoes, and gloves. The suspect had a hood up over his head and face covered with some kind of cloth in order to conceal his identity. Google Maps identifies the bank using this latitude and longitude data. A neighborhood canvass was conducted by law enforcement following the robbery, which included stores in a strip mall where the bank is located. An employee of Design Exchange, which was located nearby, adjoining the bank, advised law enforcement of suspicious activity between 2:30 and 3:30. The employee advised that unidentified African American male subjects entered the store, looked around the store for a period of time, and left. The store is a consignment store that sells home decor products. The employee thought the activity was suspicious based on the expression of the suspect's face and the interaction with the employee. As the suspect entered the store, it appeared to the employee that the subject did not expect the store to be a home decor store. Well, with a name like Design Exchange with a letter X, I would not necessarily think it to be a home decor store either. The suspect also appeared to be confused when the employee approached him and asked him if he needed assistance. The suspect did not stay inside the store for very long and did not appear to be interested in any products. The employee described this individual as an African American male, approximately 38 to 48, 5'6 to 5'8, unshaven, with a stocky body. Okay. Based on training experience, I know robbery suspects often utilize mobile cellular devices in furtherance of the conspiracies. Yep, I bet they do. I know that they use accomplices as lookouts or getaway drivers and communicate through cell phones. Often, suspects conduct pre-robbery surveillance that can determine the number of people inside. In this instance, it's probable they had a getaway driver waiting for them in a vehicle in the neighborhood north. I don't know if it's probable or not, and I don't know if that's necessarily relevant either way, but whatever. They entered through the front door of the bank. They were not seen on neighborhood surveillance video approaching the building from the rear before the robbery, but they fled out of the rear after the robbery. This identifies the suspects were dropped off in front of the building and picked up in the neighborhood north of the building. Maybe. Witnesses stated that they were extremely calm during the robbery, despite they spent approximately 7 minutes inside. Investigators who are familiar with the case believe that they conducted surveillance on the afternoon of the 12th based on observation of the employee and the physical description seen by the employee being similar to the suspect. Also, the suspect's actions in front of the bank and fleeing out the rear door is indicative of a level of planning which would have involved some familiarity with the area surrounding the bank. Probably. Based on the foregoing, it's probable that the unknown suspects of this investigation had cellular phones, which either utilize Google's Android or Apple's iOS system. I request the court issue the proposed warrant. Because the warrant will be served on Google, who will then compile the requested records in a time convenient, reasonable probable cause exists to permit the execution of a warrant at any time of the day or night. It's further requested that the court order seal all papers in support of this application, including the affidavit and search warrant, and be sealed until further order of the court, which incidentally is why we're covering this now, because as you may remember from the dates, this was back in February, and now it is September. And the reason we're covering this is because we just now have access to it because it was just recently unsealed, which makes sense. Search warrants are typically sealed. All right, property to be searched. The warrant applies to information for all Google accounts that during the time period below accessed from a mobile device located in this geographic region. 30 meters around the coordinate. So that's about 100 feet around the coordinate. So if we can find anyone who is within 100 feet in the time question, okay, fair enough. This warrant calls for information from Google and this location. And here's the bank robbery location. Very exciting. Things to be searched and things to be seized. To the extent information described in attachment A is within the possession, custody, or control, including any information that has been deleted but still available or has been preserved pursuant to a request made under a different statute, the provider shall provide responsive data pursuant to the following process. Google shall query location data based on internal search parameters as described in attachments 1 and 2. For each location point recorded within the parameters, Google shall provide anonymized information specifying the corresponding unique ID, timestamps, coordinates, display radius, and display source. Law enforcement shall review the anonymized list to remove devices that are not relevant. For example, that devices were not in the location for a sufficient period of time. If additional location information for a given device is needed to determine whether the device is relevant to the investigation, law enforcement may request Google provide additional location coordinates for the time period that fall outside. This contextual information may assist law enforcement in identifying devices that were located outside the target location or not within the target location for a long enough period, moving through the target location in a manner inconsistent with the facts or otherwise not relevant. And for those device ideas identified as relevant, law enforcement may request Google providers provide subscriber information for each associated ID. And that is all that there is with respect to that. All right. So let's discuss some of the principles that apply in Fourth Amendment law that will be relevant to this. First issue is the Fourth Amendment gives you as an individual the right to be secure in your person, your property, your possessions, your papers, and they're for you. Now, these records that they're interested in concern you. They involve you, but they're not your records. And one of the ways that you know that is that you didn't create the records. They were created by Google. They're created pursuant to Google's policies and practices for accounts that you signed up for and probably, almost certainly, were given notice of that these records are being created. They are not your records. They're not your papers. Now, you still have some privacy interest in them. Let's not get completely mistaken there. But in terms of the Fourth Amendment interest, they're not your warrants. They're not your records. They're records maintained by a third party. So the Fourth Amendment typically does not apply under this situation because of the third party exception. The idea being that if I give my papers to a third party, I don't have a privacy interest in those papers, because I've given them to a third party. They're not my papers. If I give you something that I have, I've given it to you. It's in your possession, control. Excuse me. You can testify to it. You can offer knowledge of it, and so forth and so on. Now, there is obviously a lot of controversy around this as it regards to these kinds of records and cell phone records because the third-party doctrine, which this is all involving, was not really created to deal with this kind of situation. And there have been calls from courts, including the U.S. Supreme Court, incidentally, to narrow this down because the amount of records being held in third-party control is so excessive as to be a problem. There have been a lot of calls and dicta and suggestions that this might be restrained in some way. One of the I won't go so far as to call it a leading theory, but one of the theories that has been percolating around this is the so-called mosaic theory of the Fourth Amendment. Basically arguing that while you may not have an individual right in any individual fact, if there's enough of these things cobbled together, you may have a Fourth Amendment in the collective total. So they call this the mosaic theory. There's been some courts of appeal that have played with it. I don't believe anyone's ever formally adopted it. I don't believe it's binding precedent in any circuit. But there has been some interest in this as a potential solution. So far, where the courts have intervened, they have tried to narrow things down and try to narrow down the application of them. So, for example, from cell phone records, there was this U.S. Supreme Court case relatively recently where they basically said, to narrow down the time, narrow down the scope, so as to involve less of this issue. But right now, it's still an issue that is being played with in law. To my mind, this record is very reasonably and narrowly tailored. We're looking for people within this particular location, within this particular time frame, who were accessing things, and we're going to, who might have information. Now, I would also note that there might be potentially witnesses who we don't know about. They don't seek for that information, but they might uncover witnesses that they might want to talk to, someone who might have observed something. Um, and if you think about it from like other Fourth Amendment doctrines that might apply, for example, they talked about getting surveillance records from a nearby business. Well, does that present a Fourth Amendment issue? I mean, not really, right? I mean, it's a camera that's observing what's happening in public. There's no general expectation of privacy, you know, and obtaining these kind of camera records has been something that's been done for a long time. So, initially, the way this is drafted doesn't strike me as a massive problem. But of course, once you open the floodgates of this kind of thing, you want to know like where does it end? How many records can we obtain? What kind of records? What is the limiting principle of this as we're going to apply this? If this case is okay, what cases are not okay is a very reasonable question. And I don't really have a great answer to that question, and I don't think the courts do either, because it's like, well, if this bank robbery had occurred, say, in New York City, would we be able to obtain the cell phone records for anyone within 100 feet of this bank? Within this, when that involves so many potential people, and if 100 feet, why not 1,000 feet? And what is the remote? What is the limiting principle? It's not really 100% clear. But I thought this was a really interesting case because the trial court granted this decision. I don't have an immediate problem with this decision. It seems well within the current view of the law, but the courts of appeal are playing with these kinds of cases because it's like, where does it stop? No one really knows the answer to that question. It's like, can we obtain all the records, for 3 days, from anyone who walks within a mile? That seems ridiculous. So where is the limiting principle? I don't know. We don't yet know the answer to that question. But that's the end of this case, and I hope that was helpful. And after a brief drink of water, we will continue on. Zordy asks, this case doesn't deal with compelling government to maintain records. Absolutely correct. So Google could choose to implement a policy to delete these records after a short time. Yes, absolutely correct. And that applies to everyone. Absent some other law that applies, and there are laws that deal with certain business records for obvious reasons. But absent some other law that applies, there's no particular duty to maintain records. And as long as you have a policy that you apply routinely and regularly, then it's not destruction of evidence. If your policy is we maintain these records for 6 months, after which we get rid of them, as long as you do that on a routine basis and you're regular about it, that's not destruction of evidence. That's just part of your standard business practice. So there's no requirement to do this. Isn't there a records retainment under RICO? There might well be, but then again, you're talking about a case that has actually been filed in actual notice. And once a case is ongoing, once there's been an ongoing notice, then you do have a duty to maintain records. This applies in civil law too. It's called spoliation. I can't pronounce the word properly. Spoliation. That's a tough word to pronounce, but it means from to spoil. If you delete documents or remove documents in knowledge or of an upcoming lawsuit, that's not only destruction of records, it's spoliation. You can't delete records once you're on notice of an ongoing civil matter or criminal matter. If it's part of your routine business practice to delete records, if you don't have notice, you can do it. Once you do have notice, you can't do it. You have to preserve records, once you're on notice of any sort of action that would be relevant, and that would apply in context of RICO. There might be specific provisions dealing with RICO that modifies this general rule, but the general rule is, you can't delete evidence or records once you're sort of aware of the need for them. So that would be what's relevant here.